prices, lower interest rates. I don't think this is working anymore.
Oh, sorry.
Oh, thank you. So much of the literature has focused heavily on original sin. What I'm trying to do here is focus a little bit more on the law of the bond prospectuses. So, for example, here with Argentina, here are 3 pairs of bonds they issued, all in US dollars. Within each pair, the coupon price and maturity length are the same, but it differs by governing law. One is issued under New York law, the other under domestic Argentina's laws. And as you can see, at least on the first day, there's a slight premium for New York legislation, New York law. However, despite this premium, these bonds, of course, fluctuate like any other bond would. So for an investor, you have this law on paper, but in order for the law to matter, it needs to be activated via judicial ruling so that these laws are not just merely window dressings. And when it's activated by having a ruling in its favor is when their confidence will increase to reinvest in the country, particularly after a default. So I do not expect a country, just going to court itself won't elicit a positive response from investors. They really need that win in the courtroom. Of course, what's important here is what happens during times of economic crises. Because during a default, the investor is getting lots of information from different sources. And so as much of the literature has shown, investors do use some sort of heuristic devices to consume all this information and make decisions quickly. I'm arguing that the presence of independent courts within these countries can influence how investors perceive these rulings. So countries that have more independent courts, typically democracies, are more likely to benefit from a ruling against them more so than autocratic regimes, because these independent courts are also more likely to follow rulings coming out of the United States as well. So overall, democracies will be experiencing a higher bond increase during times of economic distress when they are ruled against than autocracies. Of course, there is this question about enforcement and spillover, because these bond prospectuses in all of them, they have this sovereignty statement, saying that investor can't just go into a country and seize assets to recoup items or their losses after a default. So how do these court rulings even matter? So the literature so far has shown that when a country is taken to court or even after a decision is made, investors often won't buy any bonds that are issued by those countries until they are settled with all the creditors. So there's an effective blockade from entering the bond market again. And in terms of spillover, it's unlikely that a decision against Peru will affect bond prices in Colombia. So we don't know how a judge is actually going to rule, because they could always rule in Colombia's favor. There's not going to be spillover between countries. In terms of within countries, these rulings are really just about bonds under New York law, so I don't expect it to affect prices on Euro bonds. So in terms of dependent variables, I used 2 different sources. I first used daily level data of bond prices. So the dependent variable here is price at time t minus the rolling 30-day mean. I do this to account for mean reversion dynamics. And then I also use the change in the EMVI monthly bond spread. And in terms of independent variables, I use a binary variable for the creditor win, which is the treatment variable here. As a placebo test, I also include a variable for defendant winning the case, and a binary variable for when the court got the case started, and 0 otherwise. And this data was collected from the PACER website. Some additional variables for the regime type, I use the liberal democracy index. So this helps me account for the independence of courts within a country. Binary variable for whether restructuring occurred, the amount that was default on, the 12-month rolling mean of the EMVI index, and I use that dependent variable. Indicator variable for whether there's a civil war occurring and for IMF convulsion. So in terms of expectations, so with OLS, I'm using the daily pricing data, and the variable of interest here is simply the interaction between creditor win and regime type, and I expect this to be in the positive direction. So for this analysis with the daily pricing, it's filtered out where only countries who have defaulted on and during their default episodes are in the analysis. So this is specifically during times of crisis. And then I also use structural nested means models, which I'll discuss in a second. It helps account for confounding as different variables all influence each other. So it's essentially a propensity score technique. And as this is where I'm using the E and the value index, as a spread, I expect the treatment variable to be in a negative direction. So in terms of main results, so just looking at the first 4 columns at the bottom row here, the interactions are all positive and in the and significant, suggesting that investor confidence does increase during times of crises when a country is resilient. As a placebo test, in columns 5 and 6, I changed the treatment such that the U.S. bonds under New York law are considered as untreated, and it's the Euro bonds that are considered as treated. As you can see, the results are insignificant, suggesting that there's no spillover for the different types of bonds. And then for my structural nested means models, I run 3 different specifications. They're all pretty similar. I just add or remove variables here and there. So I limited it to 4 periods, meaning period 1 is 1 month after treatment, period 2 is 2 months after treatment, here being ruled against. And as you can see in the first column, period 1, the results are negative and insignificant. So this also lends support to the fact that investor confidence does increase when a judge rules against a country, and investors will buy those bonds and re-enter the market there. Of course, in periods 2, 3, and 4, significance is lost, and this is because the market has already absorbed this information. So to conclude, what impact, if any, does a court ruling have on the debt market? My results so far shows that it does lower perceived risk by an investor and lowers borrowing costs. My next steps here will be additional robustness checks and utilizing a judicial leniency design, because different judges have different propensities to rule against a country, and I need to take that into account in future analyses. Thank you.
Okay, thank you. Thank you, Monica. That's really interesting, of course. The next paper is entitled Law Shaping the Boundaries of Sovereignty. It's the People's Republic of Congo confronts its creditors, which focuses on the comics. I'm going to say this wrong. Comics. Yes. There we go. Your slides are there, and then the clicker should be over there as well.
Yeah, you step more. Okay. Okay, thank you very much. So just to introduce ourselves, Olivier Vallée is an independent researcher and is a consultant for commercial banks and governments. I am a political sociologist based just here at the Ecole Normale Supérieure. Comisimpex, for Commission Import-Export, is one of the main creditors of République Populaire du Congo, now the République du Congo. The claim it holds against the sovereign debtor goes back to 40 years and is still a hot topic in Parisian arbitration and court proceedings. This longevity merits examination, not only because it reveals the ambiguous context in which the debt was formed, but also because it puts to the test the different forms that the relationship between private creditors and sovereign debtor can take. The case has been much in the news recently. Comisimpex succeeded in having seized in France and auctioned off 3 years later a presidential aircraft belonging to the Republic of Congo. Following the auction, the Congolese government protested to French officials, which in response invoked the independence of the judiciary system and the rule of law. This was followed by other creditor assaults. Comisimpex will also be getting its hand on a number of assets of the national oil company, Société Nationale du Pétrole du Congo. The Congo case is one example among many others of the way sovereign immunity is being challenged by creditor through different enforcement assaults on the global scene. We will come back to that to conclude. So we mobilize a qualitative analysis and social science approach to follow the trajectory of a claim. During the enforcement process, the creditor's exteriority or indigeneity in relation to the Congolese state and politics is being challenged. From a supplier credit, a state public order formed in 1945 and 1984 and 1985, the claim becomes a promissory note through a political protocol. Then, under the effect of the arbitration process and the operation of law and finance, the claim finally became an award, then a genuine sovereign debt recognized by the country's coffer and inscribed in the Register of State Commitments. We describe the role of jurisdiction and creditor enforcement in cleansing the claim of its political initial context. We conclude that there is a progressive abstraction of the debt, that is to say, a process of decoupling of a chronic debt from its context, initial context. Commis receivable arise from what is known in banking terms as a supplier credit. That is to say, a commitment made by the Congolese government at the end of 1984. Indeed, the president of the time, Sassou Nguesso, 5-year plans included Commis of Lebanon in its dominant construction and public works component for an amount of 22.6 billion of francs CFA. I'm sorry if you cannot read anything there, but we understand that is the degree 0 of debt contractual formalization in terms of legal and accounting criteria. You cannot, but if you could, and we will be happy to share the slides, you can read the words possible cancellation. You can observe that in the table, suggests that public procurement is neither a priority for the government nor for the IMF, as you can see in the table with the acronym PAS, which stands for Plan d'ajustement structurel, meaning structural adjustment program in French, and meaning that it will depend on the evolution of this program. Commis a supplier of goods and services, registered as a company in the Congo, found itself holding invoices denominated in several currencies based on a commitment project entered in CFA franc under this 5-year investment budget. The financing of the Congolese state at this time is rooted in the concealment and use of pre-financing managed by ELF, the French oil company, and backed by the state's share of oil. It was in this framework, in this kind of framework, that Commis advances were developed, completing the process of oil-backed debt gagé in French. All these financing were required for the huge state investment of the 4-year plan, 1982-1986. Denis Sassou Nguesso succeeded to the Marxist-inspired government led by Mariam Ngouabi, head of the state and of the Parti Congolais du Travail from 1968 to 1977 when he was assassinated. At that time, the world experienced its second oil shock. The country found itself rapidly caught in a vicious cycle of fluctuating oil prices, withholding of oil royalties and advances by ELF, and relentless indebtedness. Faced with a cash shortage, particularly to pay the salaries of 80,000 public sector employees, its new leader had to resort to both foreign and local capital inherited from the colonial model. The Lebanese didn't leave Congo and Gabon in the troubled post-independent years. At the time when the government was undergoing financial constraints, the Lebanese offered an indispensable and unavoidable but costly recourse. Monsieur Ojej, who comes from an important Lebanese family with a strong presence in Africa, headed up Commission Import-Export, Commis in Congo at the time. With 5,000 employees, it was one of the largest private companies in the country. On behalf of Sassou Nguesso government, which was engaged in a massive 5-year plan, he would carry out a number of works, building a bridge, planting a palm grove, building a village center. Moreover, the businessman and the Congolese president were close friends, which enabled Commis to free itself from many of the constraints regulating public contracts, and their payment. The pact between Commis and Sassou Nguesso was not so much about the concrete achievement of the service providers, but about the financial resources needed at the time by the new president to establish the regime. All this evolved in the context of tension between the Western and Eastern blocks. There were 600 Soviet advisors in Brazzaville in the early 80s and 3,000 Cuban soldiers, some of whom directly protected Sassou Nguesso from an assassination like the one that killed his predecessor. Comisampex appeared as a neutral enclave between the two camps, the West and the East, in the Congo. In Comisampex, the Parti Congolais du Travail has found a faithful companion. The finance minister of the time was rewarding the company with various contracts. Following the national conference, which shook the Parti Congolais du Travail system in December 1991, the Brazzaville Criminal Court heard the flagrant crime trial of Parti Congolais du Travail President Housekeeping in connection with the Comisampex affair. He was accused of having paid Comisampex $45 million. Housekeeping had strong and very famous lawyer at the time in Maître Jacques Vergès and Maître Memba, who defended Klaus Barbie. After Lissouba's election as president of the Republic, they obtained their client's freedom in 1992, the year in which a memorandum of understanding was signed between the Congolese government and Comisampex. It was at this point that the Comisampex claim began to spiral out of control. The money claimed by Comisampex, which then amounted to around 91 million euros, reached 675 million euros in 2013. And today, Mr. Ojesh claims that the sum has risen to 1 billion, whether in euros or dollars, a tenfold increase in the original bill. But what did the promissory bills originally given to Comisampex actually cover? Proof that Comisampex had carried out the work planned in 1982 capital budget has never been established. On the other hand, the triangular relationship between the Ministry of Finance, Comisampex, and the Bank of Credit and Commerce International, BCCI, has been examined by the US Congress and the US Justice and identified as the node of a global network of corruption and for having subsidiary laundering drug money. The BCCI, the Bank of Credit and Commercial International, got involved in the Congo by buying the famous Comisampex promissory bills at a discount, and as it is done on the secondary market for debt securities. After this discount, the notes remain guaranteed by the debtor, who guarantees to buy them back at par. In return, BCCI provided the Congo around $64 million in August 1985. To ensure repayment, BCCI required the Congo to deposit $17 million in BCCI books in Paris. This arrangement was completed by the domiciliation at the BCCI Paris of sales by the French oil company ELF of the share of crude oil accruing to the state of Congo. With the oil it sold on behalf of the state, ELF repaid a Swiss bank that had advanced the People's Republic of Congo $60 million. BCCI was to have received around $20 million to pay for Comisampex promissory bills acquired at a discount. All might have gone well, but transfer to the BCCI stopped at the beginning of 1986. The Swiss bank informed BCCI Paris that the Congo had reimbursed it directly and that ELF would henceforth be its sole interlocutor. BCCI found itself holding debt security worth $40 million on the Congo, but also had to endure threats from Comisampex, which wanted to recover $11 million deposit made on behalf of the Congo. At the same time, the so-called London Club of the time was preparing to restructure the Congolese debt, and BCCI should have seen a reduction in its claim. In February 1988, the upturn in Congolese oil production enabled the rescheduling of external debt with the London Club. So, Comisampex began a new life of a financial nature, we identify a financial nature, detached, decoupled from its original tree. That is to say, the 1982 Priority Investment Program. In 1986, a court decision determined the status of the Congo's debt stock, and the Caisse Congolaise d'Amortissement issued Comis-Impex promissory notes, bond de caisse in French. CCA, Caisse Congolaise d'Amortissement, is a public financial institution that records various types of revenues and allocates them to the repayment of foreign and domestic debt. On October 1992, the head of Comis-Impex had signed a protocol agreement number 566 with the Congolese government, represented by Finance Minister Mundoga Kombo and the General Manager of the Caisse Congolaise d'Amortissement, under which the outstanding debt owed to his Congolese company was consolidated at 22 billion CFA francs. A memorandum of understanding was signed between Muamba and Comis-Impex, setting out the terms and conditions for settlement of the remaining sums due. Already at the time, this amount was controversial for being overvalued. The Ministry of Finance, who co-signed the memorandum of understanding, did not put it into effect, especially as the head of Comis-Impex, Ojej, was considered to be close to the former president of the Republic and political enemy, Denis Sassou Nguesso. I'm going to go to the conclusion because I'm being too long. On March 1988, Mosef Adjej, in possession of the promissory board, referred the matter to the International Court of Arbitration in Paris, in accordance with the arbitration clause contained in the 1992 Memorandum of Understanding. In a final award, handed down on December 2000, the arbitral tribunal ordered the Republic of Congo and the Caisse Congolaise d'Amortissement jointly and severally to pay the amounts due, together with interest rate at 10.5% per year of delay. To conclude, what we see with Olivier is that through the process of judicialization, no one seems to be interested anymore in the nature of the titles produced by the Caisse Congolaise d'Amortissement, their relationship to any service performed by the claimant, or the reason for its invoicing in foreign currency. Originally, Comis-Impex was supposed to carry out public works, the payment of which would ensure the repayment of loans made to the Congolese state. The lawsuits, the judges, the lawyers, and the investigating process contribute to the occultation of the genesis of the claim. It's as if the historical and structural subordination of the Congolese state to post-colonial oil and banking capitalism is being ignored. The interaction between the antagonist parties to Comis-Impex claim give rise to what we call alteration between Congo politics and sovereignty on the one hand, and external private creditor on the other hand. In this case, sovereign debt becomes the product of a reconstruction whose foundations are partly covered up, are partly hidden. Debt is the result of legal proceedings that have shaped a new relationship with what we describe as depersonalized, depoliticized, between the sovereign and an external private creditor claiming the rule of law. Thank you very much. And sorry for
Good. Thank you so much, Benjamin. It's a fascinating story. It's kind of a combination of a James Bond movie and many snippets, a series of unfortunate events. I'm so sorry, Livia. I realize now that I got confused. I won't lie. But please, you're welcome to come up and talk about the last paper, which is entitled Investment Treaty Arbitration as a Forum for the Enforcement of Sovereign Debt Claims. And although you focus on Gramercy versus Peru, you address other cases along the way. So welcome. This is your clicker. Thanks. And I'll remind you time.
Yeah. So thank you for the kind introduction. In my presentation today, I will focus on the latest investment treaty arbitration concerning sovereign debt, Gramercy versus Peru, which was decided in December 2022. And I will highlight how it relates to a previous trend of investment treaty arbitrations arising from the Greek and Argentine debt restructurings. In fact, the possibility that international investment protection might extend to sovereign debt claims and that investment arbitration might become an alternative enforcement forum for sovereign debt claims potentially empowering holdout creditors during debt restructurings, emerged for the first time with clarity in the wake of the Argentine and Greek debt crisis. The presentation will be structured as follows. So first I will provide some background on the uncertainty surrounding the substantive scope of the international investment regime. Then I will address how this uncertainty has played out in the Greek and Argentine debt cases. Then I will look at how treaty drafting practice has evolved in response to these issues. And finally, I will discuss the latest Gramercy arbitration. So at the heart of the problem lies the lack of clarity surrounding the scope of the investment treaty regime with regards to the nature and types of covered economic transactions. And this lack of clarity derives from the fact that the legal framework is rather open-ended. So international investment agreements typically define their scope of application in very broad and all-encompassing terms, and often refer to various forms of debt claims. The jurisdiction of the International Center for the Settlement of Investment Disputes is limited to investment disputes, but the ICSID Convention does not contain a definition of investment. And other arbitration rules do not contain even any limitation as to the substantive jurisdiction of arbitral tribunals. So in response to this open-endedness, arbitral practice has developed certain hermeneutical criteria to guide investment tribunals in identifying the types of transactions that qualify for investment protection. And these are the presence of a contribution, the expectation of gain or profit, an element of risk, a certain duration, a territorial connection with the host state, and finally, even though this criterion remains controversial, a significance for the development of the host state. So the core question for our discussion is whether freestanding financial claims that are unrelated to an underlying economic activity, such as government securities, qualify for investment protection. And this question has emerged with clarity for the first time in a cluster of investment disputes stemming from the Argentine and Greek debt restructurings. I guess most of you are familiar with these disputes, but just to give some background, after the first debt exchange in the Argentine debt restructuring of 2005, 3 mass investment arbitrations were brought by Italian bondholders under the bilateral investment treaty between Argentina and Italy. And a few years later, while the Argentine cases were still pending, another dispute was brought by a Slovak bank in relation to losses in its portfolio of Greek government bonds following the Greek domestic debt restructuring. None of these cases reached the merit stage for different reasons, but they all reached the jurisdictional stage, and the tribunals came to opposite conclusions as to whether the claims of state qualified as investments. And in a nutshell, the essence of the disagreement concerned 2 core investment features: contribution and risk. So, sorry, I forgot to emphasize that the 3 Argentine tribunals all upheld jurisdiction, even though with a strong dissent in Avaclat and Ambiente, whereas the Greek tribunal, the Postova tribunal, dismissed the claim for lack of jurisdiction. So this was the conflict. With regards to the element of contribution, the tribunals in the Greek cases, in the Argentine cases, deemed the debt issuance process as a unitary economic process to which the bondholders had participated, regardless of the presence of a chain of financial intermediaries. And they therefore argued that the debt issuance process involved a meaningful contribution of resources to Argentina. By contrast, the dissenting arbitrators and the Postova Tribunal argued that a contribution of resources is not sufficient for an economic transaction to qualify as protected investment. And what would be needed is a contribution to the productive capacity of the host state. So basically a contribution leading to a creation of value rather than a mere exchange of value. And similarly, regarding the risk element, the Postova Tribunal and the dissenting arbitrators argued that in order for a transaction to qualify as investment, it would have to imply an operational risk. So the risk linked to the conduct of a business activity, rather than the simple contractual risk or default risk that is involved in government bonds. So what emerges in these cases is the presence of a tension between two opposing normative conceptions of foreign investment transactions, one that is more centered on enterprises activity and one that is broader in scope and encompasses contractual claims and various financial claims in their own right. And it also emerges that the hermeneutical criteria developed by arbitral tribunals can in principle be bent to encompass both conceptions. So states have become increasingly attentive to the interaction between international investment protection and sovereign debt. And this has led, especially in response to the cluster of Argentine and Greek debt cases, to an evolution in treaty drafting practice with an increasing inclusion of specific sovereign debt-related disciplines into investment agreements. But it's interesting that states exhibit different policy preferences. So while some states choose to exclude sovereign debt altogether from the scope of investment protection, other states opt for a more targeted limitation of investment arbitration in relation to negotiated debt restructurings. This would imply that that sovereign debt is in principle regarded as a covered investment. And this is specifically the consistent policy of the United States and the European Union, as well as its member states. And in parallel to this shift in treaty drafting practice concerning sovereign debt, there has been a broader shift in the definition of the notion of investment, leading to a greater articulation of this definition with the incorporation of those hermeneutical criteria we have discussed before. And we arrive now at the latest Gramercy arbitration, which involved precisely a modernized investment agreement. So it is actually an interesting test case for new trends in treaty drafting practice. So the language of the United States-Peru investment agreement that was the basis of the claim was innovative in three respects. First, the definition of investment included in the treaty was rather articulated and included a specific reference to the hermeneutical criteria which we have seen before. Secondly, there was an express exclusion only of official debt, so bilateral loans between the treaty parties. And thirdly, the treaty included an annex limiting investment arbitration in relation to negotiated debt restructurings. So Gramercy is interesting also in other respects. First of all, because the claimant is a distressed debt fund. So it is the first case in which investment arbitration is used by a quote-unquote vulture fund, if we will. And secondly, because the factual background of the dispute is quite peculiar. The dispute involved old bonds issued in the 70s by Peru as a compensation for expropriations occurred in the context of an agrarian reform. These bonds remained unpaid, and subsequently even their value became contested due to currency depreciation and currency changed. And Gramercy acquired the bonds from Peruvian holders shortly after the treaty between the United States and Peru was signed. So the tribunal in Gramercy once again affirmed jurisdiction over the bonds, even though with a strong dissent of Professor Stern. And it did so on the basis of an expansive interpretation of the notion of investment included in the treaty, and specifically of the hermeneutical features which were incorporated in the treaty. And what is important is that to sustain this expansive interpretation, the tribunal made explicit reference to the presence of the annex on negotiated debt restructuring. So essentially, the tribunal argued that because treaty parties had limited investment arbitration in relation to negotiated debt restructuring, this meant that they had intended implicitly sovereign debt to be included in the treaty, and that therefore the notion of investment that defines the scope of the treaty in general terms had to be interpreted in a way to accommodate freestanding financial claims such as government securities. And this is very clear in the tribunal's reading of the elements of risk and contribution, which we have seen were already very relevant in the Greek and Argentine cases. So with regards to the element of risk, the tribunal did recognize a difference between operational risk and simple contractual risk, but it emphasized that the treaty parties had specifically intended to include transactions bearing only contractual risk. And similarly, it argued that the treaty parties had intended to include transactions bearing a mere monetary contribution, such as sovereign debt. It even went so far as to argue that Gramercy's acquisition of the bonds contributed to Peru's economic development because it turned illiquid assets into cash, essentially, by paying a couple of bondholders. So once again, the presence of the annex was important to sustain an expansive interpretation of the definition of investment. And it is interesting to note that this annex was included as a compromise during the negotiations upon specific insistence of the United States, because Peru originally intended to exclude sovereign debt altogether. And the United States later intervened through an amicus curiae in the arbitration, trying to argue that the annex was merely intended at limiting disruptive litigation and that it had no bearing on the definition of investment. But the tribunal dismissed this argument as illogical, and correctly so in my view, because it creates an artificial separation between the annex and the definition of investment, which simply defines in abstract terms the characteristics of transactions covered by the treaty. So to conclude, even though it remains contested, overall arbitral practice seems to lean towards an expansive interpretation of the substantive boundaries of investment protection, encompassing freestanding financial claims and particularly sovereign debt. And this expansive reading is further reinforced by certain new trends in treaty drafting, such as the inclusion of provisions limiting investment arbitration in relation to negotiated debt restructurings. And more broadly, the hermeneutical criteria developed by arbitral practice and increasingly incorporated in investment agreements are insufficient to resolve a fundamental tension between an enterprise or business-based conception of foreign investment and a broader conception encompassing contractual claims and portfolio investments in their own right. Thank you.
Okay, so we'll open it up for questions shortly. I realized that when we started, I didn't really give you context in terms of who I am. So I head the sovereign finance sector at the African Legal Support Facility. And that means for all of these papers, when I was reading it and when I was just listening to them now, I come from the lens of a legal practitioner who advises sovereigns in finance-related transactions and does a lot of capacity building around debt and debt management. So from my perspective, some of the things that stood out to me were first the importance of risk perception and how it is influenced and how it can be influenced. And a couple of papers talked about that. Starting with the idea you mentioned, Monica, around the idea that rulings in favor of a creditor could ultimately positively impact investment risk perception is absolutely fascinating. And that means that if you're, sitting in the government seat, what you're thinking is, wow, actually, if I lose this, ultimately it will have longer term benefits. I think for me, at least, it would beg the question of how long it would take to reap those benefits. But beyond that is clearly an interesting concept. Related to that, Jana, you have talked about the emphasis on strong domestic institutions as a necessary ingredient for positively impacting perceived creditworthiness. For us as well, kind of similar perspective, but the idea that having stronger domestic institutions is really the one thing that leads to all things good in sovereign debt, in particular in the countries that we work in Africa. The next thing that struck me was the ways in which the process of enforcing sovereign debt contracts can actually change the nature of the debt. And that's what you guys are talking about, Benjamin and Olivier. And in this case, the idea that the supplier credit kind of, spiraled out of control, if you can say that about it, becoming something much more comprehensive and kind of unbearable. And I like the way that she used the word flagrant. There was a flagrant disproportion between the initial supplier credit and the amount of the final claim. And this is particularly interesting to me in our work, as we've seen similar things in different countries. And unfortunately, this, again, snowballing effect really has significant impacts on debt positions. And when countries go to restructure and restore their debt situations, that type of debt poses particular problems. And again, this kind of, in particular, my perspective, begs the question of how do we prevent that in the initial drafting? How do we prevent that from happening earlier on so that that's not something countries have to deal with? Finally, the discussion on whether sovereign debt constitutes an investment under investment treaties that you kindly talked about, Livia, is something that quite honestly is very much overlooked, but is important consideration. So with that, I'll let you guys ask any questions that you have. And do you want to move so that you're facing, or is it, because it feels a bit weird?
Yeah.
I could very quickly move it to, oh, that's even easier. Oh, that's beautiful. Okay. There's only one question. Oh, okay, good. So why don't we let 4 people ask questions and then answer, otherwise we'll forget and lose track of the questions. So you had your hand up first.
Yeah, my question is to Jana. So it's a very interesting paper. So if I understood you, focus on currency volatility in general, not doesn't matter if it's going up or down, right? So, and if I understood you correctly, you control for a number of factors, but I couldn't see oil dependency effectively, I imagine. Although you could use actual other resources, because I think they have a interesting dichotomy where you have one factor, which is a general risk factor, and especially when you let the currency depreciate, but the stronger factor is that by letting the currency depreciate, because your government revenue mainly is in foreign currency linked, while your expenditure is in local currency, so it should be a more positive factor, even though I like to mention the case of Angola, where they let their currency appreciate quite massively in 2021, which was, well, they actually got 2 sovereign ratings upgrade there, because the sovereign rating agencies focused more on the debt stock, debt to GDP factor, backward-looking, fairly meaningless factor, rather than the actual impact on exchange or other balance of payments going forward. So I don't know if it's something you potentially will look at going forward, or something you think. Thank you.
Okay, other questions? We're going to take 4, please.
Yeah, I have a question for Jana as well. Obviously, exchange rate flexibility is one way to deal with shocks. Another way to deal with shocks is borrowing to bridge those shocks. So how do you deal with this reverse causality that's perhaps stability of an exchange rate could be because a country chooses to deal with those shocks through borrowing, and they can do that because they have limited spreads and ability to borrow.
In the back?
My question's for Livia on the Gramercy case. So just a quick Google search here seems to be that in the end they did get an arbitration award. But are there certain advantages that I don't think they've actually been paid yet? So are there any advantages from the creditor's point of view in terms of where's that action if it's coming from an exit case versus say a typical New York state law case?
One more? Okay, yes.
Also for Livia. And so practice and drafting practice as well indicate that it's that sovereign debt is encompassed by the term investment. But have you seen any drafting practice on how the state potentially try to exclude certain debt restructurings and so on? Is there any change in the drafting practice because of the risk contained by being included in the investment sphere on how to exclude, for example, restructuring use of taxes and so on? Is there a clear tendency in how states have adapted to the new practices?
Okay, great. So that was pretty fairly evenly divided between the two of you. If you want to start, Jana, with the responses.
So first question about currency volatility. So in fact, I studied the how the choice of exchange rate regime. So when I discuss currency volatility, I discuss disadvantages of flexible regimes that you can see volatility and also you can see evaluations. But in my models, I study the choice of exchange rate regime. So how how a particular exchange rate regime influences borrowing costs. So I obviously use different computations, but I kind of then aggregated them into fixed, intermediate, and flexible, right? Assuming certain effects of certain regimes, right? Your point about oil dependency, I do control for bunch of variables, but I have not included variable that would somehow account for oil dependency. I just check. I don't have Angola in my sample, so so at least in this case, I don't have much of an explanation, but it would be great. I think it's a great suggestion. I will definitely try to account for natural resources. The second question, I think, is the question about exchange, about endogeneity, I suppose. Yeah. Right. So you are right. I mean, this would be obviously very important problem in the literature and exchange rates. The exchange regime obviously, could go both ways. I mean, in terms of their impact on trade or the impact on growth, etc. Inflation, by the inflation in this particular case. I'm not as worried about endogeneity in this case because sovereign spreads, they change much more frequently than exchange rate regimes, particularly in euro. So I'm less, concerned about it. But if there's, way you think I should be somehow deal with that, I would be, happy to. But I was not very much concerned. It's true that borrowing costs can be, extreme volatility in bonds can lead to changes in regimes. But as I said, there is a kind of and the same thing about the institutional quality, right? These are also they do not change very frequently. So I'm less concerned. I have not explicitly addressed it in my paper, but I would be happy to take your suggestions.
Thank you, Lydia.
So, well, thank you for your question. Certainly, the Gramercy Award was a very partial victory. I have left it out because of time reasons, but Gramercy ended up getting, I think, 5% of the damages they asked for, because the tribunal calculated the compensation on the basis of the historic cost. So essentially, the price Gramercy had paid to acquire the bond. So this is one element. And it's a long discussion also whether investment arbitration is the most effective forum to enforce sovereign debt claims. Generally, exit have strong enforcement guarantees. So generally, yes, but there is an increasing reluctance in the sense. So I guess I'm not necessarily arguing that investment arbitration is more favorable for creditors as opposed to classic contractual litigation, but it still is another instrument, and it can create disruption also preventively with respect to debt restructuring. It's not previous to debt restructuring. And with regards to your question, I think what I have seen in treaty drafting practice is kind of a binary choice in the treaties that address sovereign debt. They either exclude sovereign debt or they go for these limitations to with regards to negotiated debt restructurings. Then these provisions are drafted in different ways. Some define negotiated restructuring, some do not, and so on. But there is this kind of binary choice, and it seems a bit of a crude instrument, a treaty provision to address all the possible situations states can face, obviously, during restructurings. And also, another concern is that investment tribunals have a weird use of precedent. And so my sense is that even though this clauses limiting investment arbitration in relation to negotiated debt restructurings might still shield, for example, restructurings completed through the use of Kearse from investment arbitration, they could still favor an expansive interpretation of investment notion, for example, in older agreements that do not have any provision regarding sovereign debt. Because you never know how arbitral tribunals are going to use precedent in which way. So.
Please. I would like to follow up on that. Have you ever seen any bond issuances where there has been a sort of contractual exclusion of treaty applications?
No, there has been discussion about this, but I haven't seen any. So I don't know that this is that this has been done. Yeah.
Yeah. Oh, I see a hand in the back.
Thanks so much. My question is also for Livia, and perhaps a bit different, but some of the rationale of the investment scheme to protect investors in context where they have less confidence in the domestic litigation. And so I'm wondering, for sovereign debt that is issued under foreign law, does that not strain the credibility of the rationale for the investment agreement, and therefore is a more plausible application foreign participants in the domestic bond market, which we are seeing more of for bonds that are issued under domestic law. And so I'm wondering how, as these conversations are evolving, what is the discussion about the law under which bonds are issued and therefore the be. And then I have a question for Jana, which is, as I understood it, what happened here is the supplier's credit sort of morphed into a promissory note that then, potentially also became more tradable and brought in other sets of actors. And I'm wondering whether that is something that you were seeing beyond the Congolese case, the sort of, in some ways, like securitizing of these debts that then brings in other actors. And so, whether you can tell us a little bit about that.
Does anybody else have any questions? So we can take two more they can answer. Otherwise, I have a question. I'll add mine then, Monica. My question is actually the one that I brought up earlier when I was concluding, which is, have you thought about the time to recovery or the time to reap the benefit? Because I was actually thinking when reading and hearing you speak about it, about credit ratings and how there's a battle by countries to avoid downgrades. And sometimes you try to convince them, actually take the downgrade now, eventually you'll recover, as opposed to trying to fight it and do all those things that ultimately might end up being more problematic than not. So if we were trying to sell that concept to a sovereign, what would be the arguments that you would make? Any other questions? There's room for one more in this round. Yes, please.
It's a really quick one for Monica. As a practitioner, found that getting a judgment on an unpaid claim is only a matter of time in New York. It's rare that you will lose. Enforcement is always difficult. So how do you, how do you account for that with the fact that judgments often their implications are very difficult to know because enforcement takes so long, so difficult.
Okay, thank you. So why don't we start with you, Benjamin?
Yes.
Your
I'm
response.
gonna give the floor to Olivier.
Okay,
Just
yeah.
for the- Maybe I will complete.
Okay. Please.
Okay, thanks. There is many channels to start to trade initial supplier credit. The word used in public accountability in French is all the case, it's a kind of things on the treasury of state. If you return to the slide displayed during the expose, you can see that 92 for the memorandum of understanding between Commission banks and the Ministry of Finance and the CCA, the post-congolese d'amortissement, you can see that all the bills, all the claims held by Commission banks could be seized to banks or financial institutions. But it was fungible, it was tradable, succeed after the memorandum of understanding. And after this promissory notes, with its supplier transformed in promissory notes, were on the market, and on the market, secondary market, after the securitization of the debt. On the secondary markets, some vulture funds and other creditors or other banks, BCCI, used these promissory notes originally credit supplier credit to marketable the
And just to complete, your question was, is there more broadly field? I think, yeah, this case also contribute to that, observing let's say, the different steps regarding securitization. But yes, of course, it's, I think, a rising practice. There's the old literature about financialization of law and the emergence of third-party funding, and there's an industry of solving disputes that totally fit in this peculiar story we are describing. It's more general than the Congo in some ways.
Thank you. And Monica, do you want to take your two questions?
Sure. So I guess the first question about enforcement being difficult. I mean, when I had interviews with various investors who have gone through this process, they have said that, investment, like actually seizing assets, going through that process is almost nearly impossible. So for them, it's more potentially the future, and there is this reaction in the bond market, but actually going to seize assets, it rarely occurs. I agree with you on that. In terms of judgments always come in time, that I kind of disagree with, especially before 2014, the Supreme Court case against Argentina, there is variation in outcome. So countries don't always lose these cases. Of course, now after Argentina, there's been a slight uptick of countries losing a little bit more in the court. And then in terms of how I thought about time to recover assets. So like in my paper, I show that like the significance of the treatment effect diminishes over time. But I do need to take more into account the length of time within court, because maybe the case has taken longer, the fact may be different than cases that were quick and short. So that's something to think about more.
Okay. Yeah, last one for you.
Thank you. I actually very much agree with you that the rationale for the extension of investment protection to external debt is very, very weak. There's also a broader discussion as to whether investment protection should extend to portfolio investment in general. But with regards to domestic debt, it's not as weak, but the interesting element is that it's not a discussion one sees in the case law. So the element of the law governing the debt is not very much discussed, even in the Greek case, where, I mean, we all know that the Greek restructuring was achieved through a retroactive insertion of the reduction clauses in the domestic law. Even there, the tribunal does not really delve into this issue, so it's not.
We have time for one very last quick question, and then I know you wanted 1 minute, right? Okay, does anybody have any including burning questions, anything like that? That means that's the sign of a really good set of presentations. Okay, so with that, I'm gonna thank everybody again for